On the telephone ending in 1336, tell us your name, please.
Dominic Hall.
I come in sui juris.
Only one of you actually has that phone number, and the other people are just wrong about what their phone number is. Who's calling ending in 1336?
Sui juris and personal persona. I'm Stephen Tyrell White, beneficiary of sovereign. I'm here under fraud, menace, and duress. Fiduciary Daniel Williams Norbeck.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try to come to court. Mr. White, are you able to hear me?
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and or $500 fines and costs. Do you understand your charge?
Objection, Your Honor. I do not. I do not understand my charges or
okay. I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor. Your Honor. You practice in front of the bench. You practice in front of the bench. That's my job or my attorney job. I'm sui juris. I'm appropriate person.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me.
Okay, but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, can I ask to dismiss the charge?
Before we even get into the chaos, let me set the stage for you because today's video is a perfect storm of sovereign citizen nonsense, courtroom reality checks, and judges who absolutely do not have the patience for imaginary legal theories pulled straight from the internet. We've got 3 different defendants across multiple courtrooms, all of them convinced they've discovered some secret legal cheat code that magically exempts them from laws everyone else has to follow. Spoiler alert, it doesn't work. It never works. And today you're going to see exactly why. In our first courtroom, Judge Norbeck immediately clocks what he's dealing with the moment the defendant opens his mouth. You'll hear the buzzwords, sovereign, beneficiary, fraud minutes, and the classic refusal to acknowledge jurisdiction. This is textbook stuff straight out of the sovereign citizen playbook, and the judge isn't buying a single word of it. What makes this case especially entertaining is how quickly things escalate from a simple suspended license charge into a discussion about jail time, cash bonds, and bench warrants, all because one guy refuses to answer basic questions. And if you think this is bad, just wait until we get to the second courtroom, where a defendant not only claims to understand the law better than her attorney, but actively tries to represent herself while facing serious prison time. This video is a masterclass in what not to do in court, and why listening to internet legal gurus can land you in a cell instead of saving you from one.
Because at this point, the prosecutor, there's no sworn testimony, there's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
Okay, sir, those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
So
my
I've
constitutional
indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all of this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to. Sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's what I'm saying.
A few things to talk about here.
This right here is why judges can spot a sovereign citizen within seconds. The moment someone starts stacking nonsense titles together, jurist, proprietor, beneficiary, sovereign, it's a dead giveaway that they're not actually engaging with the legal process. They're performing. And Judge Norbeck handles this exactly the way seasoned judges do, by removing the distraction and keeping the courtroom moving for people who are actually willing to follow the law. That what's important to understand is that sovereign citizens rely on disruption. They believe if they talk long enough, confuse the record, or refuse to answer direct questions, the system somehow collapses. But courts don't work that way. Judges aren't obligated to entertain pseudo-legal monologues, and they're definitely not required to let one defendant hijack an entire docket. By putting him in the waiting room, the judge sends a very clear message. Court is not a debate club, and it's not a podcast. This is also a subtle but powerful lesson for viewers. The law doesn't require you to agree with it, it requires you to comply with it. And when someone refuses to do even the bare minimum, judges will absolutely move on without them. That's not oppression. That's efficiency.
Subject matter, jurisdiction.
Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. I'm not sure you do. The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection. I'll travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond, sir.
It has to be before we can proceed.
White,
before you can proceed, it has to be addressed, Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, we will have this conversation again about arraigning you to see if you understand the charges. but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand? Those two options, A and B.
That's a violation of my constitutional rights, Your Honor.
This exchange perfectly captures the sovereign citizen paradox. On one hand, the defendant claims not to recognize the authority of the court. On the other hand, he desperately wants the benefits that come from cooperating with the court, like a personal recognizance bond and staying out of jail. You can't have it both ways. Judge Norbeck is actually being more patient than most judges would be here. He clearly explains the charge, the possible penalties, and the purpose of an arraignment. This is not a trial. There are no witnesses. There's no testimony. It's simply about making sure the defendant understands what he's accused of and enters a plea. And yet, the defendant keeps trying to skip several steps ahead, demanding dismissals and arguing jurisdiction without understanding what those words actually mean. What the judge is doing, and this is crucial, is offering a choice. Cooperate minimally and walk away on a PR bond, or refuse to engage and deal with real consequences. Sovereign citizens love to claim judges are tyrants, but moments like this show the opposite. The court bends over backwards to give them an off-ramp. They just refuse to take it.
Well, no, it isn't, sir. So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date for court?
This is where the wheels officially come off. When a defendant starts arguing jurisdiction without understanding it, they're essentially arguing themselves into a worse position. Jurisdiction isn't magic. It's geography and authority, and the judge lays it out in painfully simple terms. The alleged offense happened on a public street, inside a city within a county governed by state law. That's it. End of discussion. The I travel, I don't drive argument is another sovereign classic, and courts across the country have rejected it over and over again. The law does not care what word you personally prefer. If you're operating a motor vehicle on public roads, licensing laws apply to you. Period. What's really happening here is the judge drawing a boundary. The moment he says Zoom is no longer an option, the tone shifts from discussion to enforcement. This isn't punishment, it's risk management. If someone refuses to acknowledge the court's authority, the court has zero reason to trust them to come back voluntarily. That's how cash bonds happen, and this defendant walked himself right into one.
All right, you can call Ms. Tubbs' case.
Okay. Calling case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P. 36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes, Your Honor.
Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Your Honor.
Okay, then it says at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Your Honor.
Yes, Your Honor.
Right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What day?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under code UCC 1-207. And I have the rights to represent myself and waive all counsel knowingly, willingly, and intelligently.
And just like that, a simple misdemeanor case becomes significantly more expensive and dangerous for the defendant. This is the part sovereign citizen influencers never explain. They love to talk about rights and unconstitutional actions, but they never mention bench warrants, jail time, or cash bonds. Judge Norbeck spells it out clearly: show up with $300 or sit in jail. Those are the options. The judge isn't angry. He's not emotional. He's being practical. Courts operate on compliance, not belief systems. If you openly state that you don't recognize the court's authority, then expecting the court to trust you without financial incentive would be irrational. And that's exactly what the judge says, in plain language, even calling it stupid to let him walk without a bond. This moment is a perfect example of consequences flowing directly from behavior. No tricks, no traps, just cause and effect. And it's a lesson many defendants learn far too late.
And I would like to.
Right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, if once I get that, then if she wants to represent herself, then we can,
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Your Honor.
So, ma'am, I'm going to have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not going to do it, but I just want you to talk with him and understand some of the risks of doing this. And okay?
Your Honor, I understand all the risks and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now?
Now we move to Judge Slavin's courtroom, and while the tone is calmer, the situation is arguably more serious. This defendant isn't just invoking sovereign citizen language. She's facing a competency hearing and potentially years in prison. Unlike the first case, this one involves mental health evaluations, legal representation, and long-term consequences that can't be talked away with buzzwords. The court does everything by the book here. A forensic psychologist evaluates competency, both sides stipulate to the findings, and the judge carefully confirms that the defendant understands what's happening. This is what due process actually looks like. It's slow, methodical, and designed to protect the defendant's rights, even when the defendant doesn't appreciate it. And yet, despite being found competent, the defendant immediately launches into UCC codes, contracts, and declarations that have absolutely nothing to do with criminal court. This is where confidence becomes dangerous. Believing you understand the law better than trained attorneys doesn't make you empowered, it makes you vulnerable. Clip 6. This is one of the most critical moments in the entire video. The judge isn't mocking her. He isn't dismissing her. He's actively trying to protect her from herself. Representing yourself in a criminal case, especially one involving serious felony exposure, is almost always a terrible idea. And the court knows it. The reason for the oath or affirmation isn't.
Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're gonna need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions, just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I am here to, I'm here
All right,
to reserve
let's
my
have you
right.
raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you. All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not.
But I need to know what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right. Well, let's have her raise her hand again, and you say the affirmation. It's not an oath; it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No. Yeah. Okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right. Thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
punishable up to 5 years or a fine not.
Ma'am, just wait. Let me speak, okay?
I'm sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5